Solon. Solon is an organisation that will be known, I know, to some of you. And someone who's not here today, Lee Waltier, is a regular. Most of you will know Lee Waltier, I suspect. Commercial ship surveyor down in Southampton. Nick is a regular at the Solon conference, which I think is November. Nick will tell you about that. And every year he goes, and every year he says to me, I'm the only marine surveyor. I'm the only marine surveyor who goes to the conference to understand and learn about expert witness. So I just throw that out for what it is. Nick's working without a PowerPoint. This is the only slide you're going to see, which is very brave of him. So without further ado, Nick, please come up and take your place.
Well, good afternoon, everybody, and thank you for the opportunity to come to talk to you today about the pitfalls of being an expert witness. I notice I've got two slight drawbacks this afternoon. Firstly, being the post-lunch speaker, which is always a challenge. I noticed today I'm also the post-lunch, post-wine speaker, which multiplies the challenge. Just to make it even worse, I had some wine myself. So let's see where we go if we all go together. I've been working with expert witnesses with Solon for the last 7 or 8 years. And in that period of time, I've been training experts in how to gather evidence, how to write reports, how to survive being cross-examined. I don't know how many of you have been through that process and still standing. Good. Also touching on some of the dangers of being an expert witness, for there are many. And although over the years I've worked with possibly no more than about a dozen from the marine world, the principles of being an expert witness apply across the board. They're the same for doctors, dentists, marine surveyors, and so on. And I want to just touch on some of those dangers for you as expert witnesses. One thing that I thought of as I was preparing for this afternoon was that lawyers only ever turn up when there's bad news, almost by definition. And here we are again. I've turned up to tell you about the dangers. But that is the function of a lawyer. We talk about worst case scenarios, we talk about pitfalls, and so on. And sometimes there's a danger that we are, as a breed, the boy that cried wolf, and no one believes us. So I thought I'd pepper this afternoon with some stories of some spectacularly self-destructing expert witnesses from various walks of expertise, just to illustrate this stuff does happen, even though you might stand back from it and think, how on earth could anybody do that? But they did. So this stuff genuinely occurs, and it boggles my mind when it happens, but it's worth sharing the stories. Pitfalls for you as an expert witness. I think there are 3. The first one is you. The second one is the other expert witness. And the third one is your own lawyers. On the other side, they're fine. But it's your own instructing lawyers are the ones most likely to lead you astray. Now, just around the room, how many of you have been instructed as expert witnesses, whether or not you've given evidence in the courts or arbitration? Fine, okay. What I thought I'd do is just give a talk and save the last 10 minutes for questions. So if anybody wants to challenge anything I say, please do, but are we happy to leave the challenge and questions till the last 10 minutes or so? So I want to say a bit more about each of these, but the first thing to say about you being your own worst enemy as an expert witness. And this is praying in all of the self-destruct stories that I can think of. It's where the expert wants to help, but they forget who they're there to help. And the really dangerous expert is the one instructed by some solicitors, and they say, can you just give us a view on this? And they go, yes. What they mean is, no. Because it's not within their expertise. Dangerously, though, it's something they know an awful lot about because of their expertise, but it isn't actually their expertise. Does that concept make sense? Do you have a sense of what those sort of periphery areas may be like in your own areas of specialization? I'll give you an example which is fairly extreme. I don't know if you remember the bank interest rate setting case, or as it turned out to be, interest rate fixing case that was prosecuted a few years ago. Does that ring bells around the room? No? Okay, well, I'll just give you a brief background to it. Some of the banks, who probably should remain nameless, Barclays, were getting together to set between them what their lending rates were going to be. And all of this was thought to be a perfectly legitimate process until someone piped up and thought, well, hold on, doesn't this look as though you're fixing it? And they said, no, this is not fixing, this is setting. Quite what the difference is a matter for a dictionary and 20,000 lawyers. But, so some of the people involved in that process were prosecuted by the Serious Fraud Office. I think, as with most organizations, they get the difficult part of their work away in the title. What they then did was nothing serious at all. You might think, quite rightly, that they would want an expert witness to comment on general banking practice, but you might think also, again, without any fear of being contradicted, they would want somebody who is an expert in the interest rate setting business. Does that sound a logical proposition? Not necessarily to the Serious Fraud Office, who got hold of a man who held himself out as an expert in banking matters and in the interest rate setting business. And it turned out he knew an awful lot about banking, but nothing whatsoever about the interest rate setting side of it. Sadly, the Serious Fraud Office never asked him how much he knew about the interest rate setting business, although this was a central plank of their whole case. Hence, one of my thoughts that as an expert witness, your two primary dangers are you, as this expert witness found out when he said, yes, I'll give you an opinion on that, and your instructing solicitors who don't ask the right questions and don't ask for the right credentials. Do you know anything about X, Y, and Z? And it went from bad to worse. He got hold of a few mates who did know about interest rate setting, rang around them and just wrote down what they told him in his report and submitted that to court, and didn't see anything wrong with that as a way of operating. When he was cross-examined, and you can imagine what fun he had, at the end of day one, he was going to be cross-examined again the next day, and the judge said to him, you can't discuss this with anybody overnight. He said, yes, of course, absolutely right. Left the courtroom, gets out his phone, texts his mates, emails them. That was his sad bit, because that's obviously recordable, and the email trail is there, and says to them, I'm being asked about this, what's my answer? You couldn't make this stuff up. He thought this was fine. Neither the judge, nor the cross-examining barrister, nor the Court of Appeal later agreed with him. And the Court of Appeal characterized him as giving evidence on, and this is their exact wording, to put it charitably, on the outer reaches of his knowledge. That is not the sort of comment any expert witness wants to have in their CV. So what do we take from this? Being clear, crystal clear as an expert about your areas of expertise, so that when the inquiry comes in, you're able to say to them, yep, that's within my area, or you're able to say to them, actually, no, that's not me. You need to go and talk to somebody else. Simply because over the years, and having been a barrister in practice, lawyers don't necessarily ask the right questions, nor do they necessarily ask the right people. For some lawyers, if it involves a marine event, their thinking will extend no further than saying, well, you're a marine something. You must know about this. Now, I don't know if that's been your experience or not, but certainly I've come across experts who have had exactly that experience. that actually, as you will know, there's a whole range of areas of specialization within your worlds. You may very well be able to comment as an expert on a number of those. There'd be others you'd say to yourself, actually, safely, I'd say that's outside my expertise. So I think that piece of work needs to be a critical one at the outset, and be happy to say to a solicitor, don't talk to me, but do some generous networking and offer somebody else's name instead. Don't go the way that the expert in the Crown and Pabin case went. Thinking about your report, for most experts, that generally is the start and finish of your work as an expert witness. Most expert witnesses' experience is that they're instructed, they produce a report, and it disappears into this legal black hole, and you never see it again. You never hear about it again at all. For some, there's then a panicked call about a year and a half later saying, we need you in court next Tuesday, which is not a good process to undergo. But your report is your critical calling card. So what needs to go into your report? One of the main things that I've found with expert witnesses is your expertise is in the bag. That bit's fine, provided you've made that demarcation for yourself. Most experts then write the report as if they're addressing a peer, somebody who is them, and you're not. You are addressing a very intelligent audience, whether it's arbitral panel or judge or counsel, but they are not you. If they were you, they wouldn't need you. So don't write a report addressed to you or somebody like you, because that won't work. And this starts to get the report writer to think about how much explanation do I need to put in here, and how much can I take for granted. I tend to say to expert witnesses across all fields, take nothing for granted, assume intelligence and a willingness to learn, but other than that, a blank canvas, which is not an adverse comment on the English judiciary, but is a realistic comment on what they can possibly know. They're bringing you in to help them, to educate them. That's the role you're performing here. There will be, without a doubt, a lot of concepts that to you, in your areas of expertise, are so obvious, you don't even mention them. And again, I'm sure you can think of some of those as you're sitting here now, that actually this is just so workaday, you don't even address it consciously. To the judge or a member of the arbitral panel, this may be wholly alien. And so you may find yourself having to just go a little bit upstream to explain some essential concepts so that the judges are all on the same page as you. I'll say a bit about counsel, about your barristers a little bit later on, because I wanted to touch on a number of the areas where you interact with the law and the lawyers, but I wanted to dwell on the report writing bit because that is the most dangerous part. But I'll also talk about barristers later on, and how many of you have had a conference with counsel sort of just before the case starts? For some, that's been a really almost shocking experience as they start to think, oh, you really don't know this stuff at all, do you? And you're the lawyer. So yeah, we'll come back to what's going on in that scenario in a moment. But back to the report. I wanted to spend a bit of time on this. I'm not just talking about your technical language, but I'm really talking about your technical explanations. Your role as an expert witness, I think primarily is an interpreter. You're coming in because you have a certain set of expertise which the decision maker doesn't have. You are there therefore helping them to understand the evidence through the lens of your expertise. So you need both to explain your expertise and then explain the evidence in the light of that, if that makes sense. So it's no use coming in and spouting the expertise. We need the simple version. almost the Ladybird guide, just to make it really, really straightforward. And the more basic you can make it, the more likely it is that everyone will get what you're saying and therefore follow what you're saying and therefore achieve the right result, which is actually what we're all trying to do. Well, question mark over the lawyers, but certainly the rest of it. So make it simple is the first thought. Often people ask, how long should my report be? Because I'm encouraging you to explain everything, which means that your report is likely to be longer. There was a judgment a couple of years ago where the judge said, we want experts to write shorter reports, which is interesting and profoundly unhelpful because it doesn't tell you shorter than what. And in the same breath, he went on to say, and they must also be thorough. So there we are. That's easy. Explain everything, write short reports, and make them thorough. Now, I read one recently where chose to address that by reducing the font size. Fair play, but that's just cruel and doesn't work because some poor twit's got to read this, and font size is actually rather important. I met another expert a few years ago who, when I was delivering a report writing course, he was in the middle of writing a 600-page report. I didn't say this to him, but in all honesty, that's an exercise in utter futility because there isn't a living being on the planet who will read it. The judges certainly won't touch it with a barge pole. So there is no point doing that. He should at least have written 100 pages or found some way to reduce it. What the courts are looking for from the expert witness is someone who's able to distill your expertise and therefore the evidence so that we get the message. Use the appendices to do vast quantities of explanation and to store all your data. Keep the report lean and readable so that they can actually get through it. A judge at our conference, Mike was mentioning it earlier on, we have an annual expert witness conference in November. Sign up, please. We'd love to multiply the marine surveyor by several. Would be very, very good. But a judge addressing that conference said, look, it's not my business to tell you how to write a report, but let me tell you how to write a report. And what he went on to say was, give me an executive summary, cross-referenced out to the main parts of the report. So just find ways of simplifying it and getting the message across. It's far more likely that whoever's got to read it will then get it and probably even read the whole thing if you've summarized where you're going with it. So think about that for the report side. The other challenge that comes at the report writing side is when you've written your report, you've sent it off to your lawyers, and they write back to you, asking you to clarify some things for them. Has anybody had that request? Please could you clarify? Often preceded by the word just. Could you just clarify, which means we don't want to pay for it. And makes it sound like a small piece of work, and it's not, it's a mammoth piece of work. Be very careful. I'm not sure what the Latin would be for expert witness beware, but that's the big moment to beware. Are they asking you to clarify, which is perfectly legitimate and perfectly fine? In other words, we don't quite understand what you're telling us. Can you please clarify? If, on the other hand, can you please clarify actually means, can you write this, which is far more beneficial to our client's case, then I would back a million miles away from that instruction. There have been a number of cases where experts have got into arguments with their instructing solicitors because the solicitors have said, well, no, we want you to write this. The expert has said, no, I'm not going to write that because that's not what I found. And the solicitor saying, right, well, we'll never use you again. To which I think the only sensible answer is good, because I don't want to be instructed by you again if that's how we're going to operate. Commercially, that may sound quite short-sighted, but actually your biggest, what's the word? your biggest credit in the bank, I suppose to put it, is your credibility. If you're viewed as a partisan witness, that witness's career as an expert is pretty much over. So I'd guard that with every breath in your body. So beware of that request to clarify. You might have heard of a little-known English institution called the Whiplash Injury Institution, where I think fairly uniquely we claim damages for injuries to our necks when we're involved in minor car-on-car shunts. It's an industry riddled with, well, fraud is the only way to put it, really. And there was a case at the start of this year, well, where the judgment was the start of this year. The doctor in the case produced what the judge described as a report-writing industry off the back of this. He was producing 5,000 reports a year, which is I mean, do the maths, how many is that a day? And he got it down to literally seeing a claimant and producing a report within 15 minutes. The mind box. You're in the wrong business. You're working far too hard on what you're doing. And his turnover as an expert witness was £350,000. He was also a GP. Something had to give along the way, and for Dr. Zaffer, it was his integrity. He examined a claimant, produced a report, examined the claimant 2 months after an accident, and the claimant said, well, I had pain for about a week and then it resolved. On examination 2 months afterwards, the doctor was turning his head and his neck and his shoulders, wrote in his report, full range of pain-free movement in neck and shoulders. It's a categorical finding. The solicitor got hold of the report and rang him up and said, can you just clarify? Because what the client is telling me is that he's still in pain, and he's in pain right now. This is the same week that he had been examined and had no pain. And the solicitor then said to the doctor, well, so what do you think about pain resolving within 6 to 8 months? Now, I know you're not doctors, but it doesn't take somebody with that specialization to think, I don't think I want to write that down because it contradicts what I wrote. Not so, Dr. Zaffer. He then produced a completely new report with those findings that directly contradicts all of his, didn't mention that the solicitor's involved at all, made it look as though he'd made those findings himself, predated report number 2 to the same date as report number 1, didn't mention report number 1 at all. Now, does that sound like a good idea? Doesn't need me to stand up and talk about it. Nevertheless, Dr. Zaffer thought this would all be fine until the insurance company got hold of the original report. Quick quiz question. How did they manage to get hold of the original report? What happened? Anybody punt a guess out? Yeah, the lawyers, somebody in the law firm accidentally sent the wrong report. I thought that was a work of sheer genius. Whatever you do in life, always beware the twit. Somewhere who will do the wrong thing. And then the twit won't be around when things go belly up. You know, you're left with it. So he was, in fact, there was a contempt of court action brought against him by the insurance company. And the judge, and against the solicitor, and the judge said, yes, this was contempt of court. And the solicitor is now in prison for 15 months, quite right. And the expert witness got 6 months, but suspended for 2 years. The Court of Appeal said no, it should have been 9 months immediate. Cue much shuffling of chairs as everyone decides not to be an expert witness at all. But the point is made, isn't it? What the courts were saying is actually we place a great deal of trust in the expert witness. We're relying on you to be independent. We're relying on you to be truthful. It's a promise between you, the expert, and us, the court. You've signed a document. You've said this is true. we want to know that it is true, or at least that you're saying, well, the bits that I have looked into myself, I know to be true. And I've made a distinction in my report between the bits that I've done myself and bits that other people have provided for me, because you're not liable for what they've told you. Clients, lawyers, witnesses may, astonishing as it may sound, tell you all sorts of rubbish. I'm sure no one's ever had that experience. But you just need to be careful, right? This evidence comes from this source. This is mine. The bits that are mine, I confirm are true. So be careful with the urge from the solicitor to add bits into your report, or indeed leave bits out under the guise of things like, well, of course, we don't really need to mention that, do we? Well, I think we probably do, don't we? Because if that actually impinges on your expertise and on your opinion, you have a duty to the court to make sure it does go in, irrespective of what the lawyers do. Trust me on this, and I know this is Rich, the lawyer's telling you to trust him. When things go wrong, you will not see the solicitor for dust. They will not be standing shoulder to shoulder with you to face down the foes of outrageous fortune. It'll just be you on your own. And this is the experience of expert witnesses all the time. They accept slightly wobbly instructions, and then the solicitor just quietly makes themselves absent when things kick off at a later point. I'm making it sound as though every lawyer is to be avoided at all costs. There are plenty of extremely good law firms out there, extremely good barristers out there. Line up with them, not the ones who are just trying to win at all costs. So that's a little bit about thinking about your independence, about your role. Back in 1993, I'm sure you know the case of the Icarian reefer. It must be familiar to some around the room, where Mr. Justice Peter Cresswell laid down the guidelines for expert witnesses and the need for impartiality and independence, and to make sure that your opinion is uninfluenced by the pressures of litigation. Those principles back in 1993 have not changed since that date and have been adopted throughout the civil courts, and indeed were adopted by Lord Wolfe when he did his review of civil process back in 1998, and have been restated time and again by the judges. So it all started in your industry, interestingly enough. So the good old days of appointing partisan experts should have long gone. As one judge mentioned of an expert witness who was entirely partisan in another case, the judge made reference to the Icarian reefer, and he said of this expert, he said, of him it could be said that the Icarian reefer was a ship that passed in the night, which I thought was a rather nice cutting and completely cutting off at the knees comment to have made about it. I rather like that one. Let's have a quick look at the experts' discussion. Who's been involved in a discussion with another expert around the room? Fine, okay. My understanding of that essentially is that the discussion is only really as productive as your opposite number is rational. And there are plenty of examples of expert witnesses who, I don't know quite what happens, but there's a red mist that comes down and they think they're there to win an argument. That is not the role of the expert witness. You are there to help the decision maker and initially even to help the lawyers understand the case, but all in the light of the idea that you're there to help the decision maker, the panel, the judge to reach a decision. You're not there to win the case, you're not there to argue the case, you're not there to fight it or settle it or anything else. But there are some experts out there who take that as their role. And I know of an expert who it starts every discussion she goes to with the words, well, I'm right and you're wrong, so I don't know why we're here. Now that isn't a discussion, in my view. I don't see how that is a discussion of anything. It doesn't seem to advance anything at all. The other thing that comes out of the discussion is this joint statement. And again, this is an area for potential carnage. part of which is the tussle between the two expert witnesses about what they do agree and what they don't agree. And that in itself can last for a protracted period. Whatever you can agree on the day, get it agreed and get it written down. And as much as possible, be the one who writes up the joint statement. As soon as the other side starts writing up, then you've lost control of it, and they might be producing all sorts of nonsense. So just write out, well, we agree these areas, here's what we disagree, and brief reasons for it. As far as the judges are concerned, they have said often the joint statement is one of the most important documents in the case. They will go to that to try to understand what this is all about, because they recognize the experts are independent, the experts are impartial, they're going to expect it to be. Counsel are both going to argue that black is white and white is black. I know that, so there's no point in getting sort of rational state from them, but I'll come to you to understand the issues in the case. So it's a crucial document. And make sure that you sign it before sending it through to your instructing solicitors. There was a case last year where the expert had sent the draft joint statement off to his instructing solicitors saying, just for you to have a quick look at. The judge described that as a serious transgression because you do not need their authority to sign it. It is not theirs, it is yours. So just agree it between the two of you. This, of course, is a matter of huge terror to a lawyer. Lawyers, as you probably realized, are broadly very, very frightened individuals who want to win the case. If they let you out of their sight, goodness knows what you might do. And they want broadly to be able to stop you saying anything that might compromise their case later on. I would have been in the same boat if I'd remained in practice. I left practice many years ago. But lawyers are trying to maneuver the pieces around the chessboard in order to win. Experts discussing things without lawyers present, I can only imagine terrifies the lawyers and gives them sleepless nights. They're very worried about what you might have actually agreed between yourselves. But openly discuss everything that's within your areas of expertise, see what you can agree, see what you still disagree. It's a perfectly legitimate process. And you don't need the lawyer's permission to produce your statement at the end, because that's yours. It's your evidence. And actually, the good lawyers will appreciate that, because it'll give them a clear understanding of how strong or weak is our case in reality. There's no point in any sense sort of bigging the case up, because ultimately it all comes down to the evidence. What does the evidence give us? If the evidence doesn't give us a case, the lawyers need to learn that right at the outset, rather than halfway through, or worse still, as it all implodes in the witness box. So you have a clear evidence-based approach right from the beginning. If your view is this is a dead duck, tell the lawyers straight away, and they'll know, right, we're into settlement. There's no point in fighting this. Thank you. So that's your joint statement. Let me just touch on conference with counsel. I don't know what you think of barristers. I was one, so you can tell me I've stopped being one now. Barristers broadly are very good poker players and are very good at making it look as though they know what you're talking about more than you do. By definition, they can't. Even the brightest and the best will have absorbed knowledge, but they won't have done what you do. Their ability to absorb, their ability to argue and refine argument is without question, and they're a very bright bunch. What happens at the conference with counsel is that they may well be asking you some pretty sharp questions about your evidence, and actually almost cross-examining you. And I don't know if anybody's had that sort of experience. Or they might be asking you some questions and you're sitting there thinking, well, why are you asking me that now? That's such a basic issue. Why has that not been raised before? Broadly speaking, the simple reason probably is that until the case got to almost certainly going to court or to arbitration, it's on the lawyer's back burner. And so for the barrister, they're dealing with the next firefighting crisis, i.e. the next case they're dealing with in court or in arbitration, not your one, which may be in 2 years' time. So they won't read it with that sort of sharp tooth comb approach, slightly mixing metaphors there, to really to understand it and really to get to grips with it. They're now reading it, thinking about themselves standing in front of the panel or the judge saying, right, this case is about this. Here's our main points. This is why we're going to win. To do that, they need to understand it at a depth that they probably haven't tried to up until that point. Does that make sense? So this is probably why you're getting those really clear questions at the conference stage rather than before that. Better to do it then than an HMRC accountant realised. As counsel opened the case in front of the tax tribunal, the accountant was thinking, he hasn't understood our case. That point is too late. Best to get that cleared up at the conference stage, way before that. So just summing up some quick thoughts then. Your role, you're there to help the lawyers, you're there to help the decision maker to understand, you're there to help the decision maker reach a robust decision. You are, and this is the difficult part, instructed by the legal team. They are there to fight, to win, to settle, to run the best argument they possibly can. They will calmly and quietly envelop you in lawyerish bonhomie and draw you into the team. Well, what we're saying is this, isn't it? What we need to do is this. And at the same time as being part of the team, you need to distance yourself from that and think, well, actually, yes, I understand how you want to argue this, and you can probably contribute to that within your expertise, but you've got to separate off your credibility and your independence to make sure that you're not influenced in your evidence by how they want it to be portrayed. It's actually a very difficult tightrope, I think, to walk. It is walkable, but you've got to be aware of the sort of drop either side and realize that the push and the pull with it. Some experts write their reports and write their evidence wanting to out-science the other expert, which again, I can completely understand. You don't want to sound sort of dumb for the other expert to pick you off. But again, just a reminder, you're not writing for them, you're writing for the arbitrator, the judge. The simpler you can make it, the more likely they are to get it, the more likely they are to follow you. One last example. There was a case 2 weeks ago that made it into the papers. I don't know if you remember this. Made it into actually most of the UK papers and was reported in the Evening Standard Thursday of 2 weeks ago. Case of Mr. Mr. Ager, the expert witness for the prosecution on the carbon credits trading case. Anyone remember this one? Ringing some bells? Yes. Yes. Great man. The world that keeps on giving to expert witness trainers. So his approach was, he was instructed by the prosecution, actually by the investigating police officer, and there was a problem there straight away, because how do you appoint an expert witness if you're a police investigator? We were told there is a register maintained by the National Crime Agency. When Piers Lawson at Solon then checked what that actually meant, it means, yes, they hold a register, and he asked, well, how do you get onto the register? Oh, you get onto the register by submitting your CV and so on, and some references. This is sounding fairly robust. The references are what? Oh, well, the references are from the last investigating police officer who instructed you. Right, so nothing independent then. No sort of independent verification of his ability to act as an expert witness. No independent verification of his expertise. It's just the last senior investigation officer said, yeah, he does carbon credits. Oh, we'll have him then. On that basis, he gave evidence in something between 20 and 50 criminal trials, most of which are now under review as a result of him going off bang in the witness box and being revealed as not a credible expert, and certainly not a credible expert witness. two things emerged on his expert witness side, that he had, or perhaps one on his expertise. He had been a trader in carbon credits, and then left that, and there was a career gap that remained blank. And no one's entirely clear. I'm not saying anything nefarious happened at all, but there is a blank unexplained in his career between 2013 and it was 2018. Within the carbon credits world, there isn't much academic literature. There is one book written, as it happened, by the defense expert witness. The prosecution expert witness didn't know about the book and hadn't read it, which is perhaps a little bit surprising. His view was that there is no secondary market in carbon credits. Defense expert's view was, yes, there is. There's plenty of trading, and therefore the whole plank of the evidence goes away. His final bit, which was a disaster, was when he was asked about the evidence that he'd received, and he said, well, I didn't keep records of any of the evidence that I was sent, which is extraordinary for starters. And they said, well, can we see the evidence? And they said, well, no. I said, well, why not? I was storing it in my at home in the cupboard under the stairs, and it was all damaged in a flood. It's not an awful lot more sophisticated than the dog ate my homework, is it? But he thought this was fine, and he was cross-examined by the defense QC for 2 days about not only his expertise or perceived lack of it, but also his competence to be an expert witness. And what is emerging more and more now is the need not just to be an expert, that much surely must be in the bag, but beyond that, to have some input, some training, some knowledge, some demonstrable accreditation in how to be an expert witness. That's what we do at Bond Solon. We've been doing it for the last sort of 20 odd years. I've been doing it for the last 10 or so years. I would be very interested to talk to anybody who's interested in looking into this, if we're wanting to take it further. I would also highly recommend the Expert Witness Conference, as I say, which Mike was mentioning earlier on. I appreciate this sounds like a sales pitch. It is. But beyond that, I suppose two last thoughts. Actually being an expert witness, I'm told by those who do it, can be fascinating. There's lots of very, very interesting work out there, quite challenging. I think go into it, but go into it with eyes wide open to understand the dangers of it. And in the same way that you wouldn't go into what you do on a daily basis without understanding what that world is and without training in it, I would say don't go into the expert witness world without training it to understand what the pros and cons and dangers are, and indeed how to survive and thrive within it. Ladies and gentlemen, I hope that's got me to my sort of roughly 10-minute point. I'm up for any questions, any challenges that people might have from the floor. Yes, yes, right at the back, yes. I think there's some microphones coming round. Thanks.
Hi.
Hi.
I instruct all experts, and when we do it, what I do is I always ask if they've already produced their report. Sometimes they send it in draft, but I still remind them that it may be disclosed. Drafts are disclosed, as you all know, particularly or if there's something fundamentally changed. But I always ask the questions separately afterwards and ask them if they've comment, and ask them to put them under each heading that I've got, so they know the questions actually been asked by the third party, and then whatever opinion they give an opinion, which should be honest to the court, shouldn't it? And so therefore it should be quite open as to what their answers. We don't ask for any bias, we just ask them separately, and we then disclose that if you want to have to actually characterise and say, add to it, then we'll do it again, and we'll disclose to make sure there's open and honest.
Perfect. Yeah, I completely agree with that. The only thing I'd add to that, just an endorsement really from a judge from last year who said, actually the key to all of this is transparency. If as an expert, you're just transparent and assume it's all going to come to light anyway, whether it's through the twit in the office or through a legitimate process, assume it's all going to come to light and just be open and transparent. Yeah, I agree.